Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's nicest indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, for those of you who routinely geek out on the channel, you know that last night we got this video out real quick, which talked about all of the shenanigans that the Ninth Circuit has engaged in issuing now a stay on Judge Benitez's order. And I told you in that video, hey, I'd only had a chance to go through the majority ruling issuing the stay. There was 35 plus pages of dissent. I said I would get through it. I did. I said I would get another video out. I'm gonna. This is it. We're gonna talk about all of the gamesmanship. And yeah, I'm gonna tell you guys right now, your blood's gonna boil when you realize what's going on, but you're gonna be appreciative at least of a few justices in the Ninth Circuit who are actually calling everyone out on this. So today, let's get you all up to date on the chaos in the Ninth Circus. Okay, so the case we're talking about yet again today is Duncan v. Bonta and the Ninth Circuit's one, willingness to accept an en banc review of it, skipping over the three-judge panel, and two, their order yesterday to stay the imposition of Judge Benitez's order. Is the fix in on this? It most definitely is. Don't believe me? Check out the video we did yesterday to see the majority's very brief and disingenuous reasoning that they gave. Now, in that video, I said, hey, listen, there is 35 plus pages of dissent here, so I want to get through that. I've had an opportunity to do that. There is some very, very sharp criticism of what the Ninth Circuit is doing. Now, as a side note, there is rules of professional conduct that say that lawyers are not supposed to be particularly critical of the bench publicly, and I want the court to understand that this is not going to be necessarily my words. These are your own colleagues' words. Now, there were two dissenting opinions. One was authored by Judge Nelson. Judge Nelson pointed out the following. I join Judge Bumate's dissent as the majority decision to stay the district court's order pending appeal cannot be squared with New York Rifle and Pistol Association v. Bruin. But I have a more fundamental concern with the majority's decision to proceed with this new appeal en banc in the first instance. No other circuit court would allow a prior en banc panel to hear a comeback case without an intervening majority vote of the active judges. And Judge Nelson then goes on to point out that this court, this circuit, the Ninth Circuit, has actually been sanctioned by the United States Supreme Court for this exact action in the past, which is a violation of what's called Rule 46. As Judge Nelson pointed out to the majority panel, just 4 years ago, we were chastened by the Supreme Court for ignoring Section 26 in an en banc case. We should not proceed down such an uncertain statutory path, particularly when viable alternatives are available. Our decision to proceed with this process undermines public confidence in the process and our ultimate decision. I respectfully dissent. Now, that is a very politely worded but stern dissent from the majority's opinion. The other justice to author a dissenting opinion was Judge Bumate, probably my favorite justice in the Ninth Circuit. I absolutely love his writing style. And yeah, Judge Bumate did not mince words. Now, he was joined in this by Judge Nelson as well as Judge Van Dyke. Justice Bumate began his dissent as follows. If the protection of the people's fundamental rights wasn't such a serious matter, our court's attitude towards the Second Amendment would be laughably absurd. For years, this court has shot down every Second Amendment challenge to a state regulation of firearms, effectively granting a blank check for governments to restrict firearms in any way they pleased. And of course, Judge Bumate was quick to point out how they are essentially ignoring all Supreme Court precedents, as we pointed out in the video yesterday as well. As Judge Bumate put it, despite this clear direction, our court once again swats down another Second Amendment challenge. On what grounds? Well, the majority largely doesn't think it's worthy of explanation. Rather than justify California's laws by looking to our historical tradition as Bruin commands, the majority resorts to simply citing various non-binding district court decisions. And of course, this was in response to the majority saying, well, listen, all these laws have been passed since the time of Bruin and they're all still standing, so therefore it must be constitutional. That is literally the depth of the Ninth Circuit's analysis. Judge Bumate also pointed out There's no serious engagement with the Second Amendment's text, no grappling with historical analogs, no putting California to its burden of proving the constitutionality of its law. All we get is a summary order, even after the Supreme Court directly ordered us to apply Bruin to this very case. The Constitution and Californians deserve better. This is essentially a judge in the Ninth Circuit telling the rest of his colleagues that you are absolutely flipping the middle finger to the United States Supreme Court. The judge also pointed out, with this background, California cannot make a strong showing of irreparable harm sufficient to tip this factor in favor of a stay. California argues that without a stay, large capacity magazines would immediately flood the state. But as we've said, California does not suffer any harm by being prevented from infringing Second Amendment rights. And for whatever reason, this particular circuit has an absolute disdain for the Second Amendment and has an absolute disdain for any lawful and responsible gun-owning resident within that circuit. As the judge pointed out here in his dissenting opinion, over and over, our circuit has enjoined government actions that would lead to the deprivation of constitutional rights, much like the district court did here. We have done this for the First Amendment, the Fourth Amendment, and the Fifth Amendment. Today, the majority proves yet again that our courts treats the Second Amendment as somehow inferior to the others. But the right of the people to keep and bear arms cannot be dismissed as second class. And ultimately, Judge Bonta then sums up his dissent as follows. This court has repeatedly acquiesced to the violation of California's right to bear arms. Now it does so again without even analyzing the merits of this case. Enough should be enough. We respectfully dissent. So I understand why all of you have boiling blood right now, because is gamesmanship being played with your inalienable rights? That's exactly what's happening for the sake of a political agenda. Now, what can be done? Because we know the Ninth Circuit's going to want to sit on this thing and age it like fine wine now. Well, there's likely going to be a petition for emergency review by the United States Supreme Court. As we know, every circuit has a justice which oversees that circuit. The bad news for the Ninth Circuit is that is Justice Kagan. The likelihood that she's going to allow the Supreme Court to intervene based upon her rulings is pretty remote. However, let us also remember by Supreme Court rule that if Justice Kagan denies review, then the plaintiffs would have the right to petition to any other Supreme Court justice. This is a case that must be reviewed by the United States Supreme Court. It must be reviewed immediately. There is a 6-3 majority opinion from a year ago that the Ninth Circuit is absolutely wiping their rear end with at this particular point, and the Supreme Court needs to step in right now, if for anything, to preserve the rule of law. Listen, the case once again is Duncan v. Bonta. There are going to be plenty more developments. You guys may get sick of hearing about this, but this is one of the huge battles that we absolutely must prevail on. We'll link the case up below so you can geek out it on for yourself. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information, it's right down there in the description box. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.